I'm very pleased to welcome everyone, our speakers first and foremost, and also the audience from all around the world. It is appropriate to say both good morning, good afternoon, and also good evening, actually, since we have not only experts and speakers from all over, but also we have attendees connected from the Americas, Europe, and Asia. My name is Andrea Chmielewski-Bigazzi, and I have the pleasure of coordinating Privacy Rules. Our alliance of legal and tech experts on privacy and cybersecurity has now spread in 50 jurisdictions worldwide. The 50th one joined us yesterday, and so we will announce this new firm on board in our next newsletter. We are growing further, and we are very happy for that. With our members, Privacy Rules is ready to provide multi-jurisdictional and multi-subject advice to companies, institutions, and entities dealing with data, both at local but also in transnational level. I very much welcome everyone to visit our platforms and subscribe to our newsletter and our social media in order to receive regular, professional, and independent information about privacy, data protection, and cybersecurity. Today, we address, of course, the topic of the moment, the pandemic and privacy. We do so in a positive way, knowing that luckily in many countries, life is going back to some sort of normality, and yet health safety poses a challenge to the way that employees can return back to the office, and their data can be collected, processed, and possibly exchanged with authorities through various applications and etc. Of course, we all express our solidarity, our sincere solidarity to those of you who are still in countries where normality is far to come. Please keep staying home, and may you and your communities be safe soon. Today, we debated this very interesting topic, very actual topic, with our experts from the US, and I welcome Mike Nitardy and Victoria Beckman, from Frost Brown Todd in the US. We also have Jean-Christophe CHEVALLIER from Ydès Avocats in France, Europe, and we have Padraig Walsh, which is partner at Witt, but also chair of the Privacy Rules Know-how and Training Committee from Hong Kong. So thank you very much, all of you, for being here. I am pleased also to pre-announce, and I will elaborate a little bit more at the very end, that this month in June, we are airing the 2 live webinars. At the same time, we are pleased to say that you are all participating in our first live webinar. So thank you very much for being here in this kind of premiere of Privacy Rules. There will be a question time at the very end of the presentations of our speakers. Unfortunately, our speaker from Singapore, Ruth and Jean, could not attend the webinar for some last-minute issues, and that's it. Thank you very much for being there. Please prepare your questions for the very end of this presentation, and I leave the floor to Mike. Mike, thank you very much for accepting being the shepherd of this very interesting webinar.
Andrea, thank you very much. It's a pleasure to be a part of this. It's a pleasure to be asked. It's a pleasure to be moderating this great panel. The way that we're going to start today is we're going to give each of the panelists an opportunity to, I guess, reintroduce themselves, give us a little bit of a snippet of the work that they do. But most importantly, for our purposes of this conversation, we want them to then answer the question of, to what extent did your country or jurisdiction where you practice law lock down or limit the ability of individuals to physically go to work, of course, other than what we know as essential workers. And then after that answer, if you could also let us know where your country currently is in the process of easing those restrictions. So we'll go ahead and start off with Padraig from Hong Kong. And if you could introduce yourself and let us know where Hong Kong stands on those issues.
Certainly. Thank you, Mike. And well done also on pronouncing my name so absolutely perfectly, because that would be usually the first thing I would do when I'm introducing myself. So I'm a partner here in the corporate commercial practice in Tanner DeWitt in Hong Kong. with a particular focus on the technology sector, and within that, looking at personal data privacy and cybersecurity issues. Now, to answer the core questions that you asked, Hong Kong finds itself in a special situation, I think, when it comes to COVID-19 and its response to it on two counts. One, there is an embedded know-how in Hong Kong, because a few years ago, Hong Kong went through a quite traumatic experience with SARS. And by virtue of the response and the learning from public health services and the public health sector to that traumatic incident, there were two consequences. The government had a better knowledge and a better approach in terms of knowing how to respond to this particular pandemic, but also in terms of the society response. There was a remembrance of things past in Hong Kong, which meant that the willingness and the cooperation of people, in fact, almost to lead the government towards the kinds of measures that needed to be taken to make sure that that COVID-19 was combated. And that was very much there from day one. So that helped Hong Kong to have a lead in many ways, certainly in comparison to maybe some other countries and other jurisdictions. The other advantage is that Hong Kong is quite a small place. There are only so many ways into the region, and there are only so many ways out of the region. And the major valve and the major control mechanism for Hong Kong were the points of access to the territory. So what happened pretty quickly was that there was a restriction on persons, particularly non-Hong Kong residents or non-Hong Kong passport holders, re-entering the region. So there is, and that's still in place to this day. Apart from that, if you are a passport holder or a visa holder, if you re-entered and you had been in other locations for in the past 14 days, you were immediately placed into a government quarantine facility, and you stayed there for a period of 14 days or longer with testing during that period of time. And now there is a very effective and efficient approach to testing at all entry points into Hong Kong. So any flight that arrives, you're immediately tested. It takes a few hours. The results are there. If the results are negative, you go right through. If the results are positive, you go to a quarantine center. So it happens at the point of entry. Easy to do because there are only so many ways into the place. Small region, airports, ports, and that's basically it. Other things that the government did that helped in terms of combating COVID-19, well, they introduced the quarantine centers that I've mentioned. In terms of work arrangements, the government went into a really restricted working regime. Only essential services remained. They didn't impose that as a mandatory lockdown across the territory, but they actively encouraged businesses and business leaders to facilitate flexible working arrangements. And many businesses chose to do that. Now, they also imposed restrictions in respect of public gatherings, initially to no more than groups of 4, with particular areas of the city being told to close down, those being bars and public houses, major impact on the Irish community in particular. There were also karaoke bars and other entertainment venues were closed down. Church services also, although church services have recently resumed. Because of the lack of, we've had a reasonably good run in respect of a low number of locally transmitted cases. And some of those restrictions are now slowly being relaxed. So in respect of government working has by and large returned to normal. The courts are operating, for instance, as they were originally. Jury trials even have resumed. Then if you look across the economy, the areas that had been specifically locked down, so bars, public houses, karaoke, church services, all of these have resumed normal operation. There is still a restriction in terms of groups of 8 or more in terms of public gatherings. But that is, I think what the government is doing is slowly beginning to relax. In a specific work context, what you find is that many businesses have already returned to normal, but with checks in place within the workplace. And some businesses are on a on a 2-team approach, where one team is working remotely one week and then exchanges with another team that would be remotely working the following week. So that's where Hong Kong has been and where Hong Kong presently is, but rather unique circumstances in Hong Kong.
Very good. Thank you very much. Thank you very much. Jean-Christophe, how are things in France?
Hello, everybody. So thank you, Michael, for coordinating this this webinar, and thank you to PrivacyRules teams to organize this very interesting live webinar. Today, in order to introduce myself, I am the Jean-Christophe Chevalier, partner of Ydès, co-chairing the IP-IT department. And we are a member of PrivacyRules now for 2 years, and quite happy to take the opportunity to join this very interesting network. What about France? I mean, how can we say that France? Before the lockdown, everything was good, and we were not afraid of anything, and we were not thinking about anything. I would say about that. I will not complain against anybody, but we were not. We were not afraid of the situation. And when the lockdown started in March 17th, we discovered that the French government decided to introduce very strong measures to block everything and to, let's say, oblige people to teleworking. So we discovered most of the companies, several companies discovered the teleworking. As for Italy, sorry, and as for any other countries in Europe, we had to implement very strong security measures, safety measures, like imposing to people social distancing, washing hands, and so on. But in order just to come back to the question of telecommuting, it was, let's say, this was the rules, and therefore the employees and the companies, they had to take binding rules and binding measures to allow their salaries and employees to connect and to work accordingly, and to be able to connect to the servers and so on. So even if we are talking about, when we talk about technical companies, it's easy. When we talk about structured and organized global companies, it's very simple to organize. But when we talk about small company or small law firm as well, it can be very complicated to organize that and to manage it. So the employers were not, they had to implement very quickly the measures were given and granted by the French government. So I'm sure you heard about all the different measures that the government has taken to help the company to financially help the company and support the company to live in this context, and especially the restaurants that closed their doors, the airport that stopped, and the borders that were closed. And we discovered something that we never seen for many years, was the travel authorization. I mean, not the travel authorization, but the declaration that everybody had to fill in every day just to go out of his home and to show that he was allowed to leave. I think in Italy it was exactly the same. So if you wanted to go and buy just a baguette, you should just show up a paper that say I want to buy some furniture. So yeah, it was the situation was a bit crazy. The economy is now going deeply into the crisis, and the rules in the company were strong and are strong now. Since May 11th, we started the plan of deconfinement. So that means that we are going to go out. And now I can say, so the government issued some additional rules and new protocols, like we have recommendation regarding the capacity by space that we have to follow, the flu management, personal protective equipment. We may have to organize some tests. So in contrary with other countries like Germany or in UK, or the government did not consider that testing was the good opportunity to fight against the COVID. But so now we can make some tests and we can check whether we have symptoms, so we are infected or not. And in the case we are infected, we will discuss it later, but we have to advise our employers. And so we have also protocol for managing symptomatic person. That means if you receive a symptomatic person in your company, or if you met somebody like this, you have to confine yourself, and you have to, or otherwise you have to invite your employees to confine themselves. And now, since today, I would say the country is green, because this is clearly today, June 2nd, the country is green. Everybody can go out, everybody can go back to work, respecting some restrictions. The only restriction that are live and very strong is around Paris, because Paris is not only the capital city in France, but this is the orange city. All the country is green. So we, for instance, we have reopened the restaurants. We can go farther than much farther than 100 kilometers than before, instead of before, and we can now go to see our family everywhere in France. But the only difference is, but this is quite something very important, because as you know, French people love gastronomy, is that the restaurants are reopened everywhere in France, but in Paris, it's only the terrace. So for the moment, until June 22, it's the situation, and I hope that we will be able to retrieve our way of life very soon. So.
Very good. Thank you very much. And Victoria, for the United States, I know that we have 50 different situations, but if you could give us a little bit of your background, and also bring us up to speed generally with the US and what they've gone through, what we've gone through.
Thank you, Michael, and thank you to Privacy Rules for inviting me to be here. I work at Frost Brown Todd. I'm located in Columbus, Ohio, and I'm the co-chair of their privacy and data security team. I work with Michael very closely. I'm also the chair of the Latin America desk. And as Michael just said, the US is a different beast. We don't have necessarily a national federal unified law in terms of privacy, and there are some federal statutes that cover employment laws and things of that nature, but for the most part, each state is on its own and has its own restrictions. So it is a very different country than Hong Kong, for example. We are a large country with large concentrations of people in cities like New York, Los Angeles, Chicago, and different states reacted at different times as well. So each governor, according to the situation, decided to close certain businesses. Some of them have a definition of what an essential business is that is different than the neighboring states. Some of them shut down everything at once, and some of them didn't. Some of them haven't even gotten to that point, and some of them are easing restrictions right now. So we're kind of all over the map as to what has been done and what has been implemented. There's been, as you probably know, a lot of division and some protests as to what is considered a violation of freedoms, and I imagine, like in the rest of the world, a lot of businesses had to adapt very quickly. So it seems like overnight, businesses had to go to have their employees working remotely, and some of them were not prepared, didn't have the capacity, didn't have the software, the hardware, the structure to do it. In fact, in a law firm, and we are pretty well equipped, but we still had to deal with, for example, some of the legal assistants working from home, some people that had to be there, like a receptionist, and we just kind of adhere to whatever the state says. There is some federal guidance, and the CDC has made some recommendations. The CDC is the Center for Disease Control, about social distancing, wearing masks, or at least encouraging employees to wear masks, and even customers in shops and restaurants, limiting capacity of employees, for example, coming at different times, making sure that the flow of people is in one direction or the other, no sharing food in businesses that have cafeterias or something like that, some setting like that, you're not supposed to have it. And also a lot of businesses, including our firm, has implemented self-checks, where you kind of have this questionnaire that you fill out before you even go to work, and if you have any symptoms or you think you may be affected by COVID, then you don't go to work. So it's kind of a bunch of different regimes based on the culture of the organization, the size, the location. Big companies like Microsoft, from early on in March, decided to send all their employees home, and they're not having them back apparently until the end of the year. Same with Twitter. Google has announced similar measures, and so we're just kind of slowly going back to normality.
Very good. Thank you very much. And I think that it's fantastic getting to hear everyone explain the current state where they are currently, because I think that you can see the similarities and also some differences. And to that extent, what we're going to do now is have some specific questions for each of the panelists. But having said that, we want to invite the other panelists to where, if there's something that is diametrically different in their country to the answer that they hear, to pipe in and to let us know how things are going or being approached in their country. And so, Padraig, once again, I'm going to start with you. And we know that a lot of the jurisdictions are requiring their employers to implement systems for monitoring their employees. Such as here, I know in Kentucky, one of the things that a lot of the businesses had to show is that they were ready for their employees to come back to work. And so part of that is monitoring for either symptoms or characteristics that might tend to indicate COVID-19 symptoms or exposure. And to do that before their employees are be allowed to resume in-person work. To that end, what can employers ask their employees regarding their health status in connection with COVID-19?
Actually, in terms of monitoring of employees in Hong Kong, in many ways, the kind of guidance that that employers have followed has been guidance that has been out there in different forms for different purposes already. So if you were to look at it through a personal data privacy lens, for instance, the same kind of principles apply. Principles such as, well, if you're collecting personal information, you inform the employee of what information it is you need, the purposes you're going to use it for, how you're going to hold it secure, and how long you're going to hold it for. So the same basic principles apply. You're just applying them in a different circumstance, and in a circumstance where, if anything, there is broader latitude from an employer's perspective, because that the notion of their privacy being an absolute right simply doesn't exist in Hong Kong. It is a right, but it is not an absolute right. And certainly balancing that against society interest and public health, those are very, very strong counterbalancing measures that give employers greater latitude. So one of the things that we told employers to do from the outset was to look at their personal information collection statements and to update them to the extent that they weren't sufficient for present purposes in respect of collecting essentially health-related data from employees and asking them to self-report or to respond to direct questions on symptoms they may be experiencing. And many did that. It was simply a matter of updating the personal information collection statement, delivering it to employees. Employees generally understood because there was already that societal buy-in in Hong Kong. Then in terms of the questions that you would ask, you would look at principles such as data minimization and proportionality. So you would only ask the questions that you actually need to know in order to be able to perform the employer's obligations and duties, again, taking into account, the broader public health concerns. And that was also a basis on which, for instance, you could do things like temperature checks in respect of people who are arriving at the office, or in respect of, and that could be employees or people who are visiting the office, or asking employees questions if they have been traveling. This is more true earlier in the COVID-19 period rather than right now when travel is virtually impossible. Where they had traveled or where they had returned from in the previous period of 14 days and signing off on declarations to that effect. And likewise, if people did report symptoms, then you would apply similar principles in terms of how you would handle that. You would ask, it's not something where you would immediately do a message to all and say, oh, so-and-so said he was feeling a bit hot this morning, just sharing that with you. That would not be the right approach. It was more of a situation where you would deal directly with that individual, and that information would be treated confidentially, and the person would be told to self-quarantine at home. The information of who that was and the reasons why that person was working from home would not be disclosed across the rest of the employees or the rest of the workforce, because there was no duty to disclose unless it was a situation where there was a positive diagnosis. Now, if there's a positive diagnosis, the position changes somewhat. In that situation, you do need to tell people that there has been a positive diagnosis of a person who is working in the office. But even there, you should look at the principle of proportionality. You do not need to, and you should not say who, because the identity of who does not change the way you would respond to that particular circumstance in a workplace environment. You are still going to treat everyone in that workplace environment as being a close contact, and those people will need to either certainly be tested, but possibly go into either self-quarantine or government quarantine as a consequence. That is going to be the same regardless of the name of who it was. So what you really did was you found that you had a broad latitude to ask the information you needed in order to meet your obligations in the context. But there was still an expectation that you would do what was necessary, but no more, and that you would apply that type of principle across the board in respect of what you were gathering. And you would also let people know that as soon as COVID-19 was over, or as soon as the relevancy of the information that was gathered had ceased, then that information would be destroyed and would not be retained further.
Very good, very good. And you, at the very end of that, when you just said that, that actually is going to lead into one of our other questions, but I'm glad you brought that up. And so what we have here is employers that are trying to keep their places of employment and the places of business safe, trying to keep do their duty in keeping the virus from spreading. And so one of the ways to do it is through obviously asking their employees when they come back to work, or daily in our instance, what symptoms they may have. But another way is going to be through contact tracing. And there's been a lot of talk about governments employing contact tracing apps, or what Google and Apple are calling exposure notification apps. But not just governments are getting into that space. We're learning that employers are starting to do that as well. And so, Victoria, I'd like to ask you about that. What are the restrictions that are placed on employers that want to use contact tracing for their employees?
Well, as Padraig said, it's fairly similar. And again, one of the issues in the United States is that we don't have a federal privacy law that covers the country. So we don't have, like in Europe, a GDPR that we have to follow, or even a national constitutional right to privacy, like in a lot of other countries. So we haven't developed so far a national contact tracing app, but individual employers, particular employers are doing that for their own employees. And there is different approaches to that. There is obviously tracing with GPS, with Bluetooth, with cell site location. And like with everything, employers need to apply the privacy principles, for example, minimization, purpose limitation, confidentiality. In terms of tracing or taking temperatures of employees, which is not necessarily the tracing, but in terms of that, we do have a federal statute, the American with Disabilities Act, ADA, and normally under ADA principles, you or an employer cannot ask or prohibits an employee from medical examinations unless they are job related or consistent with the business necessity. And taking a temperature is considered a medical examination. However, for pandemic times, there is an exception made because having somebody with COVID-19, like in this case, it could be a direct threat to the safety of the other employees. So you can take the temperature and you can keep that information. So what to consider employers that are trying to implement this? Number one, there are different biometric laws in the United States. There are only 3 states so far that have them: Illinois, Texas, and the state of Washington. The Illinois one is fairly strict, and keeping temperatures or any other symptoms or things like that are considered biometric data, and you have to follow restrictions in terms of obviously providing notification and written consent in those states at least. Other states don't have biometric laws, but you have to obviously provide notification to the employee. And you have to, as an employer, you have to understand the kind of information that is being collected, the purpose of that collection, where the information will be stored. And also when choosing, the fact that an app may have a lot of different functionalities doesn't mean that you need to implement that. I mean, how invasive is this tracking going to be? Are you going to have some wearables for employees inside of your company, or are you going to track with GPS location where your employees have been and where they spend the weekend? And so is it through GPS or Bluetooth? Is it stored in the individual's device or an individual device, or is it centralized in a server? Is it too much data? And of course also means that employers have to guarantee the safety of this information. So internally, you need to have the processes to make sure that this data, sensible data, is protected, is compliant with your information security program, complying with cybersecurity requirements. And obviously, if there was to be a breach for this type of information, there is some kind of implied assumption that there is damage, at least in the US, because if your password gets breached, you can go ahead and change your password. But if your biometric information is breached and there are certain personal identifiers, there's really no way to change that. So there is some guidance as to what you can do to monitor. For example, there's also in the US the ECPA, which is the Electronic Communications Privacy Act, and it gives some exceptions as to whether or not you can trace or at least follow employees. But again, in the United States is very much an state approach, a state-specific approach to this type of things.
Very good. Thank you very much. So what we've seen so far is we've talked about what employers can ask employees and what employers are asking employees, whereas essentially where employees are giving the information, and then the contact notification or exposure notification is going to be that employees themselves probably aren't aware of that they've been exposed. So two different ways that we're getting this information. And Jean-Christophe, after the employers are assembling this information, they're going to want to organize it. They're going to want to analyze it. But then the question becomes, what limitations are there on how such data can be processed? And I thought that you would be the perfect person to ask this because you're our representative from Europe in the GDPR. And so what can employers do with this information after they get it?
Actually, I will talk about France, but I will talk also about the GDPR. Under normal circumstances, the employer is not allowed to collect any personal data regarding the health of its employees. That means that for any reason, you cannot collect personal health information regarding your employees. The only way that you to collect them is when the employee gives you the information that is sick, and he has to declare the situation. So, for instance, an employee who gets sick should only inform his employers of his sick leave without any further details about the state of his health. That means I don't need to. I am sick. I don't need to tell you the reason why I'm sick and what I am, why if I have been infected by the COVID, for instance. But in the context of the pandemic, which is the topic today, an employee who works in contact with other people must inform his employers in the event of contamination and or suspicion of contamination, just in order to advise the employer that he might run up their co-workers and make sure that the security is kept into the companies and for the salaries, for the employees, sorry. So that means that you have to personally ensure your own safety as an employee, but you also have to take care of your other employees or your colleagues, and therefore you have to inform the employer according to the labor code, the French labor code. You have to do that. So in other words, it is forbidden for employers to question their employees about the potential symptoms of COVID. Okay, so you cannot take the temperature. You cannot test people in front of the companies. You cannot. You can only ask to your employees to inform you in case they have the symptomatics and they want to avoid coming in the office. Once you get this information and once you decide to, when you understand that you have an employee that is sick, then you have to collect and to process the personal data according to the GDPR. And so you have to follow up to follow the data protection rules and the principles set out by the GDPR. So first of all, the process has to be legitimate. What that means that the processing operation shall be carried out in the context of the crisis on a legal basis. Okay, so the legal basis is the execution of the public interest, first of all. Otherwise, to comply with your own legal obligation as an employer, which is I have to take care of the security of all my employees. So it will, let's say, I can see that it's like a bit hypocritical, because you say you cannot collect, you cannot ask, but when you get the data, you have to comply with the rules. So this is the way we live, and this is the way European Parliament and the French government consider that we have to comply with the rules. Then you have to follow the principle of minimization and proportionality. As you remember, that means that only data that are adequate and relevant and limited to what is necessary for the purposes for which they are processed may be processed. What that means that you cannot keep the data for undeterminate period of time. When the employee come back, you archive the data. You don't keep the data in the record. Like you point out that one employee got the COVID, so you keep it and record it in his archive for all his life in the company. So, and you have to minimize, and the processing has to be proportionate with the situation. So as I mentioned, the data retention period has not to be long, and then you have to inform the employee about the purposes, the security measure that you have take to keep the data safe and so on. And this has been pointed out by the European Data Protection Committee and the CNIL, that they consider that you have to provide a very clear, let's say in a very clear and simple language, the finality, the purposes of this data processing, the time period for what you keep the data, where are the data stored, and with who do you share the data. The answer will be the only people that you will share the data in the context of the COVID will be the health authorities, nothing more. Because I know that the question will be that. So this
no, you're right. You're right. Very good. Thank you very much. Yeah, and that's exactly what we're going to be getting to here in a second. And Padraig, we did another webinar last week, and we got into the ethical impact assessment, and so we're talking about a lot of information potentially that employers are being either asked or allowed to monitor of their employees. And I guess my question is that what are the pros and cons of asking and allowing employers to do just that?
Well, I think if you're to deal with the cons, because they're the ones that most immediately come to mind, if you look at the potential impact, particularly if you, Victoria mentioned that you have some employers deciding to deploy contact tracing apps within their own organizations. That hasn't happened in Hong Kong. It has only happened at a government level in situations where people have been quarantined, where they have been required to wear a contact tracing wearable device so that the authorities could keep an eye and make sure that they were complying with quarantine restrictions. The reason why it becomes more problematic if you go beyond, say, health authorities and government authorities is because it's quite a complex issue. With these types of technology solutions, you've got three elements that are at play. You've got the technology aspect, you have the personal data aspect, but you also have an ethical aspect, as in what is happening within society, and are you balancing society interests against other interests that might be there if you simply look through a narrow lens of personal data. And if you look at a technological view, oftentimes someone who is creating an application is looking at a particular problem, and they're looking simply to solve that problem, not necessarily thinking of the broader consequences and ramifications of doing so in the way that they have done so, or managed it at a technology level. Now, when you look at things in that context, and then you move it to an employer's organization, you wonder, are companies, are employers really equipped to make those kinds of impact assessments? Now, if you're to look in Hong Kong, where we are still in the infancy of doing privacy impact assessments, don't mind say ethical impact assessments, you would really wonder whether or not the employers are really the best parties to decide to take on board contact tracing apps and require their employees to do so. I would expect that it would, if you look at, say, a minimization principle, that you would look at alternative solutions first and only come to a contact tracing application solution if it's a situation where other options are simply not as effective or are have been tried and failed. And you could see that arising, in particularly in high-risk situations. So if you were maybe in a healthcare institution where part of that institution was dealing with patients who had or were diagnosed with COVID-19, then you could understand why maybe you would want, because of that higher risk, a solution that was more reliable and more, you could see why that might be something you would think about. And you could also think about that in terms of quarantine centers, with people working in quarantine centers. Again, other high-risk areas where maybe in those circumstances, the simple situation warrants a stronger response that might warrant contact tracing applications and solutions. And you also have the whole range of issues as to, are the systems in place in respect of how the data is going to be stored, how the data is going to be processed, who has access to it, is it secure, is it going to be destroyed when it needs to be destroyed, will the data subjects be able to have access to that data and to make sure that it is correct, or just to see what is there. All of those issues would rest with the employer. Are employers really willing to take that on board? Probably not if there are alternative solutions.
Very good. No, and that is fantastic. That's exactly at the heart of, I think, of on the broader context, what all of this is about. And so leading into that, Jean-Christophe, you had kind of mentioned this at the very end of your last response, is what if a public health authority comes to an employer and says, okay, give me all of your information because we've got a pressing need for it? How should employers respond, and do they have to give their notice to employees if that request is made?
Once collected and processed, I mean, if the CNIL, which is the Data Protection Authority, arrives, then the CNIL shall not be able to access to any data regarding the employees, especially when we talk about the health, because normally you should not collect any data regarding that. But in terms of information, the only people that should receive this data regarding the health of the employees is the health authorities. So therefore, that means that the employer has to be able to communicate to the health authorities the situation of his employees, but nothing more. No other authority, French authority, can request and require more additional information about that. This is the first point. And the second point is that the employee definitely has to be informed about this information, but he is informed of this situation in the context of his employment contract, because this is the labor law. When you sign your employment agreement, your employment contract, you are informed that the only authorities that can receive data from your employers is the health authority when it relates to health insurance services and so on. So this is the point, and the rules have not changed. I will not change about that.
Very good. Thank you very much, Victoria. So we talked a lot about what employers are going to be doing, can do, how they should do the monitoring of employees when they return to work. But let's talk a little bit about for the employees that are working remotely, that continue to work remotely, what are the implications of monitoring those employees while they're still working at home, i.e., to make sure they're productive and things like that? And then also, if you would talk about what are the other privacy and security concerns presented by working remotely?
Well, there are a lot of implications of monitoring your employees, the same that Padraig and Jean-Christophe mentioned in terms of ethical considerations, security considerations, security of the information, and obviously a moral and a cultural issue in terms of, do you have to monitor your employees? How do they feel about it? Are you monitoring because of the nature of the tasks that they're doing, and even for their own safety to avoid, for example, any potential lawsuit as to what they're doing? Or are you monitoring because you don't trust that they're going to work the 8 hours a day or 10 hours a day that you want them to work? Again, in the US, there are different approaches in different states, but in general, as I mentioned before, there's the Electronic Communications Privacy Act of 1986 that covers this kind of monitoring, but it has some exceptions, and I think employers could use these exceptions. For example, there is the business exception that allows employers to monitor the oral and electronic communications of employees as long as there is a legitimate business reason for doing so. And in some states, you can monitor the employees as long as you obtain the consent. Some states are different. Sorry, for example, states like Illinois, again, California, Maryland, require an all consent of the parties, where everyone involved in this surveillance or any kind of electronic communication, surveillance or even telephone calls should give consent before you start the monitoring. And a few states like Connecticut and I believe Delaware, for example, have specific laws that apply to the monitoring of employees, but they're all laws. So now they're raising the issue of, do they apply when the employees are working from home? And that's kind of been a question in Delaware. So again, once working from home, then you have to have a lot of different cybersecurity issues that you have to approach. For example, when this happened, as I mentioned before, employees had to go work from home, and companies were not necessarily prepared to have a workforce working from home. They were not prepared in their actual systems configuration, but also they didn't even have the equipment sometimes. So there was a rush to have all these people connected, and that could create a lot of security issues in terms of, whether or not you can handle that remote access, whether or not you even have the policies in place to have the remote access. You could see, for example, that employees are accessing your company's network with their own devices, and sometimes even with a family computer where, mom, dad, grandpa, kids access the same laptop where you're working. For employees like us, attorneys, there is the attorney-client privilege issue that you have to keep your communications privileged, and there's been some cases, for example, with smart speakers that are recording what you're saying, and technically could be recording a conversation that is supposed to be privileged, and whether or not it will have to be disclosed later. So in terms of IoTs and smart speakers, for example, there are recommendations to use strong passwords to make sure that your employees are using VPNs, but obviously you should have had in place the policies to enforce, or come up with them at the last minute to be able to enforce that. Have the employees review the default privacy settings of these IoT devices, privacy of the information in the computer, and even just hard copies of documents and confidential information. And as we saw with the increase of COVID, there was also an increase in scams and phishing emails and social engineering attacks. And so it is important to keep your employees trained and aware on how to recognize this. In the US, for example, with this stimulus check, there's been a lot of scams with people sending emails pretending to be part of the Internal Revenue Service, or we need this information in order to send you your stimulus check, and there has been an increase of 3 or 4 times more the amounts of social engineering scams being reported. And you obviously have to make sure that you have an incident response plan in place, and that you have had an incident response plan in place, because if there was a data breach, now this data breach is going to be, you're going to have to be working remotely. And as I said, you're probably going to have to work with devices that are unknown, that may not have software, the same software compatible programs that you have. And another important issue that we need to consider is contractual obligations. A lot of times, even in compliance with GDPR in the US with CCPA, you have contracts with vendors and third parties where you are taking on the responsibility of keeping the information secure and keeping certain systems that follow international recognized industry standards. And if you have your employees working from home, you may not be able to comply with those requirements. So either you have to make sure that you complied or review and have a conversation with those third parties as to, for now, we can do X or Y because our workforce is working remotely. I think that's a lot of considerations that I have said.
Very good. Thank you very much, Victoria. Well, that brings us to the end of the prepared questions, so that we have a couple of minutes open for questions from the attendees. And I guess I'll throw it to Andrea and Alessandro to see if there's any questions that have come in.
I'm sorry, the microphone was muted. It
That's
happens
okay.
Always. As probably
Yes.
happens often that Victoria's surname is mistaken. So Victoria, I apologize. It was a lapsus before.
It happens every day, don't worry.
I can imagine. Actually, there is a question that came predominantly to all of us in the sense of privacy rules, because the question was whether the webinar would be available afterwards. So the answer is yes, and I already answered privately to the attendee who was asking these, but I can say to everyone that actually by following Privacy Rules website, on the top right corner of the screen, you will see webinars and podcasts, and this webinar, which is being recorded, will be published over there. But I actually, I have a question, and I leave to Mike to decide whether he wants to distribute it to everyone or not. The question is, we were discussing about the possibility to ask information on the health status to the employee. And we understand that actually there are very different frameworks, but how far can we go in your different jurisdictions in the US to ask the status of family members? Is there any way that actually one can ask, okay, how is people in your family, how is people within your social contacts, whatever the definition of social contact can be on various countries, or even acquaintances. Can we shed some light on this? Because I believe that actually many employers, especially in particular, because as you mentioned, there are some requirements to protect the other employees. So the employer has a duty to some extent to investigate or to ask. So what's the situation out there in this regard?
That is a great question, and I will I'm not going to punt, but I will open it up to the esteemed panel. But I will say that here in the United States, what is recommended is not to be specific, not to ask specifically, but to ask it more generally in terms of not specific family members, but have you been in contact with anyone that has had symptoms? Or have you been in contact with someone that has been diagnosed with COVID-19? So that's the way that we've recommended to keep it. So then it's more still about the employee than it is about the other people, if that makes sense. But I'll throw it out to the rest of the panel to see if they have any other thoughts.
Well, if I may just kind of complement a little bit of what Mike said, I agree with that. There's obviously a difference between contact tracing or following for purposes of national health and distributing resources and hospitals and things like that, where you want to know where the person has been and where, if they have been in contact with family members or with other people. And it's very different to the obligation of an employer to keep the workforce safe. So you can definitely ask about symptoms. You can actually send people back if you consider that they're displaying some symptoms of COVID-19. But again, you need to apply the principles of minimization and transparency and all the principles of privacy in terms of, do I really need to know if their aunt, uncle, and cousin also have COVID-19 in order to keep my employees safe? Probably not. So then you don't go that far.
Right, and I intercept here because there is a question coming from an attendee. The question is, what are the prospects of the US adopting universal privacy laws? Are you aware, so I guess that this question is for Victoria and Mike in particular, are you aware of any progress that is being made in this regard?
I laugh because it's such a mess. Well, the prospects in terms of there is a lot of proposals right now in terms of a unified privacy law, and in fact, there's been two different proposals that are kind of aligned with political views and the two main parties as to how to do privacy in terms of COVID-19. There's always kind of been the same obstacle with this, and it's two main obstacles. One is enforcement, whether or not the individuals should get a private right of action or should be some kind of enforcement by the Federal Trade Commission, and if so, what's the jurisdiction and the powers that are going to be extended or given in addition to what the Commission already has. And then the other obstacle are arguments as to whether or not a federal law will preempt existing state law. So as we know, California has the California Consumer Privacy Act that is fairly strict. It may even be modified to be more strict with a proposal in the ballot for November, which is kind of how the CCPA actually started. And states like California are saying, okay, let's say in a year or two, we have a federal privacy law. It's not as restrictive as ours. We don't want to apply that. We want to make sure that we apply ours. So what are they going to do? Is it going to be in conjunction with 50 different state laws, or is it going to say, no, this is it, and you have to apply the federal regulations? So proposals, there are a lot on the floor. My personal view is that we may not have a federal privacy law in the next year, 2, even 3 years, despite the fact that the legislature from both parties have admitted that is necessary. I think the differences and the fact that there is already state laws being enacted and being discussed on legislature floors across the country will make it very difficult to pass a unified thing in the next year or two.
I agree.
Perfect. I think then, because we're already 2 minutes beyond the first hour, which was the only hour allocated to this webinar, I think it's my unfortunately my duty to actually close this session here. I really want to welcome to thank definitely all of you. Mike as first, who did a great job in coordinating this webinar, not only today but definitely beforehand. And of course, thank you to Victoria, to Padraig, to Jean-Christophe, and also Alessandro from our side for their great contribution. I see that there is another question that just came. I don't know if you feel comfortable to answer, to stay for a few seconds more, everyone. Can you? I see pretty much everyone nodding. So the question is, the DIFC in the UIA, I must confess that I'm not very familiar with what DIFC is. Probably, Alessandro, you can quickly check it out. Has just passed a new data protection law, I believe, with a view to gaining equivalency with the European Union, I guess probably to align with the GDPR. Are there any institutions where equivalency has been achieved by a non-nation state? I don't know if the attendee can clarify what is meant for non-nation state. I guess probably that's not very clear to the panel.
I guess if it is not EU countries, probably.
A non-member state.
Yeah.
Okay.
The free zone.
Probably, Jean-Christophe, this is a question related to adequacy decisions. in relation to the GDPR, conformity with the GDPR framework.
Yes, it might be the question, but I will need to check to be able to answer, because if there is an adequacy decision that has been made by the EU Commission regarding EYFC, which is, as I understand, a free zone within the AE, sorry. Yeah, we will have to check. I will not be able to respond like this.
Okay, I can recommend two avenues to the attendee who asked this question. The first one is, in any case, to check for any adequacy decision in regards to the GDPR. Actually, the European Commission publishes all of them on its website, so they are visible there. The second avenue is that PrivacyRules has a member in the UAE. So I warmly invite you from the UAE actually to consult with our member over there, and you will find details about our member there on our website, www.privacyrules.com. The third is, in any case, our Belgian member is a law firm specialized in advising the European Commission on adequacy decisions. So that could be a third way. You will find the contacts about them again on our website, www.privacyrules.com. I think I have to terminate here. This was the premiere, as I said, so I really thank all of you for being there. It's been a pleasure. It's been really a pleasure, and I want to anticipate that we are going to have other live webinars. Today, we hope that it starts a long series of where we can present all our members. The next one will be on tracing applications, so will be specifically related to that. And it will be in the third week of June. The exact date will be published on our platforms soon. And the second one in June will be, we know the date, will be on the 23rd at 4:30 Central European Time, and will be with experts dealing with cyber criminality. And it will be related to how cybercriminality increased in the times of pandemic. As we know, unfortunately, hackers have been very active in a variety of ways, and Europol has published a report about that. And we will have Europol speak with us and with our experts. We will have also members from research institutes debate about the report together with some of our members from Europe, and not only, but also from the Americas, so to have a full international perspective. The warm invitation to everyone, definitely to register to our social media newsletter, and definitely if you have any question, follow-up question, please contact Victoria, Padraig, Jean-Christophe, Mike, and if you had prepared any question for Singapore, also Ruth will be available via email. Once more, thank you very much, everyone. It's been a pleasure.
Thanks, everybody.
Thanks, everybody. Bye.
Bye.
Bye-bye.
Thank you. Bye.